Welcome to the McNees Food and Beverage Law podcast series. In this video podcast, attorney Adam Santucci details key labor and employment law issues for food and beverage industry employers. Mr. Santucci is a member of the Labor and Employment, Food and Beverage, and Esports practice groups at McNees.
Businesses in the food and beverage industry face a number of challenges. Efforts to comply with legal and regulatory requirements probably seems like running on a treadmill. Employee and workplace issues are no different. The goal for all employers is to ensure compliance with legal requirements and provide a working environment where all employees can thrive. The legal and regulatory challenges probably seem like they change from day to day. Let's talk about 3 recent workplace developments that should rise to the top of your compliance checklist. Compliance with the Me Too movement, sexual orientation and gender identity in the workplace, and the proliferation of unique state laws. Let's start by discussing best practices to prepare your workplace for Me Too. The goal of the Me Too movement is to shed light on and ultimately eliminate sexual harassment and sexual misconduct in the workplace. There are a number of best practices that you can implement to prepare for and prevent harassment claims. First, you should make sure that you have an updated, state-of-the-art anti-harassment policy. If you have not updated your policy in the last few years or longer, now is the time to engage counsel and update your policy. Your policy should clearly define what is inappropriate harassment, provide examples of conduct that will not be tolerated, and make clear that employees engaging in prohibited conduct will be subject to disciplinary action. Your policy should also encourage employees to report harassment issues. Supervisors and managers, in turn, should be required to report harassment concerns. In addition, the policy must have a very clear reporting procedure and prohibit retaliation. In addition to updating your policy, you should provide training to all employees. Employees really need to understand what is expected of them in the workplace. They need to know what behavior is in bounds and what is clearly out of bounds. Employees should also learn how to make reports of harassment concerns. Training for supervisors and managers should focus on their key role in preventing harassment and responding to complaints. An updated policy and employee training will go a long way to prevent harassment issues in your workplace. But you also need to be ready to respond if there is a complaint. If you receive a report of possible harassment, you have to be ready to conduct a prompt and thorough investigation. The investigation needs to be well documented from beginning to end. If your investigation concludes that there was a policy violation, then you should act swiftly to address that violation. The goal of that remedial action will be to make sure that it never happens again. Your corrective measure must also be very well documented. Also, whether you conclude that there was a violation or not, you must ensure that the employee who filed the complaint is aware that the investigation has concluded, what you found, and generally what steps you've taken. In addition to preparing for the Me Too movement, employers in the food and beverage industry need to be aware of the changing legal landscape regarding sexual orientation and gender identity as protected classes. Federal law prohibits employers from discriminating against candidates for employment and employees based on certain protected classes as outlined in the law. Currently, those protected classes include age, gender, race, religion, national origin, and non-job-related disability, among others. Federal law does not expressly prohibit employment discrimination or harassment based on sexual orientation or gender identity. However, a number of recent federal court cases have held that sexual orientation and gender identity are protected traits under the law. These cases hold that discrimination based on sexual orientation and gender identity are essentially a form of sex stereotyping. Sex stereotyping, in turn, is a form of sex discrimination, and thus, discrimination based on sexual orientation and gender identity is a form of unlawful sex discrimination. Several states have passed laws now expressly prohibiting discrimination and harassment based on these protected traits. There are over 20 states with laws on the books prohibiting discrimination and harassment based on sexual orientation and gender identity. What does all of this mean for employers in the food and beverage industries? First, you should make sure that your equal employment opportunity and anti-harassment policies are updated to specifically reference discrimination and harassment based on sexual orientation and gender identity. In addition, you should ensure that your supervisors and managers understand the importance of complying with those updated policies, both when making employment decisions and when addressing complaints of possible harassment. Sexual orientation and gender identity discrimination is just one area where the states have begun to set the tone for employment laws. States have been increasingly passing laws that impact the workplace, and if your organization is operating in several states, you will need to be aware of the laws applicable to your out-of-state operations. Some states have passed laws requiring that employers offer paid sick leave to their employees. Other states now require paid time off for family-related absences. Some states have passed laws that protect applicants for employment, including laws that prohibit employers from requesting salary history information and laws that prohibit employers from discriminating against unemployed candidates. Food and beverage employers must also be aware of the marijuana laws in the states where they operate. Some states have legalized marijuana for medical purposes, and some have legalized it for recreational use. In other states, marijuana is not legal for any purpose. Each state law is different, and often these laws provide certain protections for employees and candidates for employment. Whether any of these laws apply to your organization will depend on the specific language of the statute, the size of your workforce, and the states where you operate. The attorneys in the McNees Food and Beverage Group are able to help you develop the policies, procedures, and best practices that will allow you to be compliant and provide that work environment where all your employees can thrive. Please contact us using the information on the screen.